Yes, thank you. Thank you, everybody, to be here. My name is Betty Kappa. I am the president of the French American Business Council of West Florida here in Tampa Bay. Everybody knows under the name of FRAMCO. And as a dedicated leader in the French American business community, I just wanted to say that FRAMCO is the key connection between businesses. So every month we do a webinar for topics for our business or personal, if you have any questions. And so I thank you, Charles, to be here. Charles Touvenot is one of our board members, and he's the housekeeping. So you will hear him a couple of times and making sure that everything works. And this will be recorded, and you will have the video on our YouTube channel. So thank you, everybody, to be here. And today we are lucky and very proud, and thank you, David Willig, to be with us talking about probate and succession. So I'm just going to read your bio if you allow me. So David Willig holds a Bachelor of Arts degree, French language and literature from the University of South Florida, and received his Juris Doctor degree from the University of Miami School of Law. As a law student, he clerked in a Japanese law firm, and after becoming a member of the Florida Bar, he took the bar exam in France and has the distinction of having also become a member of the Bar of Paris, France, on the basis of exams. From the beginning of his law studies throughout his career, he has been immersed in the area of international private law, including as a practitioner of business and property law and litigation, estates and succession, immigration law, and numerous assignments as an international law expert in courts in Florida, France, and New York. Mr. Willig was chair of the International Law section of the Florida Bar and remains a member of the section. As he among the first to qualify to be a civil law notary after passage of the Florida legislation, creating a new type of notary, different from the notary public and more similar to those notaries practicing in civil law jurisdictions such as France, most of the continental Europe, and most countries in South and Central America. He is the director of the National Association of Civil Law Notaries and the informal ambassador for NACLN to the International Union of Notaries. David Willig has always maintained a strong interest in languages, both personally and professionally. An early inspiration was his college job as a ship handler's representative in the ports of Tampa Bay, where he was first introduced to languages as diverse as Japanese, Portuguese, Korean, and Romanian. Among graduate studies in France at the National Institute of Oriental Languages and Civilization, he audited advanced courses in Japanese, while also completing first-year university-level courses in Korean and Indonesian. At the same time, David completed 2 brevets in legal translation at the Institute of Comparative Law of the University of Paris II for English and Spanish. He is fluent even at a professional level in a number of languages and has studied many more. So please help me welcome Mr. David Willig.
Thank you, Madam President Betty Kappa, for that beautiful introduction. I appreciate it. And I also appreciate Director Charles and his helping out in the background to make sure everything flows technologically without any hitches. So today we're going to talk a little bit about probate and succession. It's going to be brief because I think we only have about 20 minutes and then we'll take the questions. So it's going to be a kind of a general outline. But I wanted to start, since I think many of you are French people or Francophone people, just to explain initially that probate, the word for probate, comes from the Latin word for prove, to prove, typically to prove the will that somebody has left, or to prove the heirs to an estate. And it's, I guess, somewhat similar, in a similar vein. Succession is related to the verb succéder in French, which means to follow. And so that talks about the rights that follow from the decedent to the heirs of that decedent. So I'm going to focus mostly on Florida because it's FRAMCO, Florida, French Chamber of Commerce of West Florida, but we also will mention a couple of things that distinguish the administration of estates in France from the administration of estates in Florida. Florida is fairly typical of what you might call the Anglo-Saxon jurisdictions. In Florida, we actually have a statute law that adopted the laws of England as they existed on July 4th, 1776, date of the Declaration of Independence in the United States. So when, unfortunately, something happens to a person, everybody has to come to an end sometime, and that's really where the probate process is likely to begin. Now, in the United States, just as in Florida, rather, just as in many states of the United States and many countries following Anglo-American law, probate is a court proceeding. That often surprises some French people who typically think of an estate administration as being managed or handled by a notaire, a notary. And as our president mentioned, we have established in Florida a figure called the civil law notary, which is intended to be similar to a notaire in France. Now, in France, it's also true that the notaire can act only as long as there is no discord or disagreement among the interested parties to the estate, interested parties mostly being the heirs or the beneficiaries of the estate. And once a conflict arises among those people, which we call in French les ayants droit, then the notary is no longer able to act, and it's likely or almost certain that the matter will end up in front of a judicial court in France. So in Florida, when we start a administration of a state, we start with a petition to the court, the probate division of the court. And that petition can be a testate estate, in other words, an estate that has a will, or an intestate estate, an estate where there is no will. And in France, the intestate is called ab intestat, very similar. And both of them, in Florida, in the Florida statutes, there is a legislation or a law, a written law, that explains, in the absence of a will, a valid will, who is entitled to the property of the decedent. Similarly, in the French Civil Code, there is an intestacy provision within the code that designates who is entitled to the property of a deceased person in the absence of a will. So the estate administration in Florida is most likely to be initiated by the person who is indicated to be entitled or have an interest in the estate. If it's a testate estate, that is one with a will or a testament, that person may be named in the testament itself, or there may be a methodology set out in the testament to determine who will be the PR. In the case of an intestate case in Florida, the PR is usually chosen by a majority of the interests of the interested parties in the estate. So in other words, if there are, let's say, a parent who dies, the last of two parents dies, and let's say there are three children, if there is no will, then 2 out of the 3 children can carry a vote to determine who would be named as the personal representative, we call it in Florida, to represent the estate and administer the estate through the court. The PR in Florida is similar to what might be called an executor in other jurisdictions. However, the notion of an executor or exécuteur in French law is a little bit different. And in fact, an exécuteur in France in French law can work alongside a notaire. It's not somebody that will work independently of the notaire. And again, once there may be a conflict arising among French heirs, then the case will end up in a judicial court, and the notaire will no longer be involved, and the executor very likely will not be involved as well. Now, I mentioned the appointment of the PR in Florida, and since many of you perhaps are overseas or live overseas or have loved ones overseas, in Florida, typically the personal representative must be a resident of Florida. However, there is an important exception in the statute law, which provides that a person who is in lineal consanguinity, in other words, in a direct line from the decedent, a bloodline from the decedent, that person can act as a personal representative in Florida, even if they live in another jurisdiction. But aside from that, the PR in most cases is going to be a resident of the state of Florida. Now, one of the things that once the petition is submitted, there are a couple of documents that the court would need to enter on the docket in order to establish officially, if you will, that the PR, the personal representative, is in fact designated to speak for and act for and administer the estate. Typically, those are an order admitting the will to probate, if there is a will, an order appointing the person representative, and as I say, in most cases, it will be the person representative who has petitioned for the administration. And then the third one is probably the most important. That is a document called Letters of Administration. That is the document, the last one, Letters of Administration, which actually confers upon the personal representative the power to do what the PR is designated to do in administering the estate. And there's a couple of things that they do. Number one, obviously, they want to have the will admitted to probate if there is a will. And if there is no will, they want to take steps to determine who the beneficiaries of the estate will be. Additionally, and this is an interesting difference from the practice in France, the PR of a Florida estate is also charged with determining who may be creditors of the decedent's estate. And a creditor of the decedent's estate is a person who has a claim against the deceased beginning from a time before the date of death. Obviously, after the date of death is a whole different situation. It's more likely to be determined to be an administrative expense of the estate administration. But the creditors in Florida have to be determined under a Supreme Court decision some years ago. If you have an idea that a creditor may be, in fact, a creditor, you have to send them a direct notice. You can't rely on a published notice to the creditors that the estate is open, and that gives them a specific period of time in order to make a claim against the estate. And the difference here is that in Florida, as in many states in the United States, the passive portion of the estate, or the debts of the estate of the decedent, are actually dealt with by the administration and paid through the estate directly, whereas in France, the passive part of the estate can be charged to the heirs, the ayants droit themselves. That's why in France, historically, you've had a decision to be made by beneficiaries of an estate where they can either accept the estate, simply accept it, they can reject the estate, or they can accept the estate with a conditional based on the inventory. An inventory is a list of the assets that the estate that belong to the estate or correspond to the estate. And so in order to avoid having responsibility for that passive or debt, passive amounts, then in France, it's possible to opt out of an estate. Of course, in Florida as well, one can opt out of an estate for whatever reasons, but would have nothing to do with the opting out heir being charged with the responsibility to pay the debts of the decedent. So, as I say, in the United States, this is part of the estate administration. It's paid by the estate. You might consider that, as we say in English, it's 6 of one or half dozen of another. It ultimately comes down almost to the same thing. However, most people feel a little bit uncomfortable with the idea of being responsible for the debts of the decedent, whether it's their own parent or some other person. Now, I mentioned that the creditors, once they're given notice, they have a period of time in which to make a claim against the estate. And what will happen in that situation is they will file their claim with the clerk of the court, because as I said, probate administration, whether testate or intestate, is always a judicial proceeding in Florida and in the United States in general. And so the creditor will make the claim, and it's up to the PR, the personal representative, to either accept that claim, which means in many cases just doing nothing for a period of a few weeks or a month, or they may object to the claim. If they object to the claim, the creditor then has the option or the possibility to file a lawsuit to recover the amount of the claim. Now, nominally, the lawsuit is brought not against the estate, but against the PR, the personal representative. However, if you have in the future offering the role of PR to play, it's not really a lawsuit against the PR personally. It's a lawsuit only against the PR in their position or status as the administrator of the estate. Now, once the creditor's period has passed, the PR, who has in the meantime also marshaled or gathered up the assets of the estate, can then make a distribution, and that's usually requires another petition to the court to make distribution, including providing for a distribution plan of how to distribute the assets to the heirs of the estate. And then I would say the last large step in a probate proceeding in Florida and the US generally is the discharge of the personal representative when all of the duties for administration of the estate have been completed. And obviously the discharge is very important, because without a discharge, there may still be some vestigial or remaining liability on the part of the PR. It might involve taxes, it might involve perhaps an heir might come out of the woodwork, as they say. So you definitely want to get the discharge once your the role of the PR is complete. Now, I want to talk a little bit further about wills or testaments, because we did mention it in the context of the administration of the estate, but as long as we're talking about it in probate, I want to talk a little bit about wills. Most people consider the proper form of a will is what we sometimes call the authentic form, similar to an authentic will in France, which would be signed before a notaire and two witnesses. This is consistent with a convention, an international convention of Washington that I believe was made around 1961, if I'm not mistaken. And that proposes that the best way to make what some people refer to as an international will is with two witnesses and some kind of a notarial authority to attest to the signatures of the wills. Now, in Florida, we have a variation of that authentic will, which is called a self-proving will. And that's a will where you have not only the notary or notary public, but we also have the two witnesses who will attest that they signed the will as witnesses along with or in the presence of the testator, the person who's making the will. Testator for a gentleman, testatrix, just like testateur, testatrice in French. So the testator or the testatrix would sign along with and in the presence of the witnesses to the will. In such a case, the notary or the notary public cannot be a witness to the will. It must be two independent individuals, because an oath is actually administered not just to the testator or testatrix, but also to the witnesses. And the notary or notary public cannot attest his own oath or her own oath, certainly not in Florida anyway. So that's the authentic will or the self-proving, as I mentioned, in Florida. Now, there's also a couple of different kinds of wills that are often practiced in France and are not really practiced in Florida. And I'm thinking particularly of, in French, you call it the testament holographe. We use the word holographic will with an aspirated H at the beginning. And a holographic will is a will written entirely by the hand of the testator or testatrix. And they're not valid in Florida. And I have actually seen these done by people who live in Florida, but they may have gone to France for whatever reason. I had one case, for example, where an American woman who spent a lot of time in France, lived most of the time in France, had a number of assets in the United States, but had a testament holographe, a holographic will in France. Fortunately, she caught it in time before her demise. She's still alive, I'm glad to say, but she did change a will and create an authentic will. And I had another instance where the testatrix lived in Florida, in Tampa, as a matter of fact. She was of Persian origin. She went to France just to visit some family members, and while in France, created or made an holographic will, testament holographe, in France with a French notary, written entirely in Persian. Now, the language of being in Persian wasn't the problem. The problem was that because the woman was domiciled in Florida, the place of the opening of her estate, the family members who were counting on that handwritten in Persian holographic will were rather disappointed when they had to turn to the intestacy statute in Florida, and that created a whole different set of beneficiary rights among the people who, some who thought they had rights ended up with none, and some who thought they didn't have any rights or had less rights came out with more. So there's a couple of interesting examples how a holographic will can create problems in Florida. So if you do have assets in Florida, and I know that many French people do, they might have a second home or other properties, it might be a good idea. Generally, I don't really usually suggest making a separate will for Florida assets or U.S. assets and a separate will for French assets. However, it's a practice that's not unheard of, and indeed, in some cases, it can make things smoother. But I think the best thing is when you have a situation like that to have some mention in the will of the existence of the other will, whether it's a will governing French property or in a French will saying there's a will governing U.S. property. In Florida, for example, there's jurisprudence or case law that says where a decedent has real property in a jurisdiction other than Florida, and that could be the state of New York or it could be the French Republic, that person is almost deemed to be considered almost like having two separate estates. And the Florida probate judge would not have any jurisdiction to make any orders regarding property, real property especially, that is situated in a foreign jurisdiction. So that's something to mention, that not all assets would be transmissible by the will. Particularly, as I say, you can put in the will the foreign property, but the probate judge will not be able to act alone on the foreign property, and it may be necessary either to invoke a notaire for that portion of the will, or again, if it ends up in a conflict situation, it might end up in court in Florida. Now, there's a couple of other kinds of properties that are not directly transmissible by will, particular to Florida, at least one of them. In Florida, we have a concept called homestead property. It's enshrined in the Florida Constitution, and it protects property from creditors, but it also protects property for the heirs of a decedent, because in many situations, the homestead property will not be transmissible by the will, but will be transmitted automatically to the legal heirs of the decedent. Another example is perhaps not unique to Florida, but there is a status of property owning in Florida called tenancy by the entireties. Maybe some of you who have dealt with Florida real estate, I know that, for example, our president is involved in real estate. And so you may have heard of fee simple ownership, was really owning all of the property. You could also have a life estate. I'm going to mention that in a little bit, but a life estate gives you the right to live on the property, to rent the property. But once that person is deceased, there might be a remainder person named, a remainder interest, just like we have in French, the usufruit, And then you have the new propriétaire, who is the person who owns everything other than the usufruct rights. We actually have that word in English as well, usufruct. So the other one was tenancy by the entireties. I didn't get to that. I mentioned fee simple, tenants in common, joint tenants with right of survivorship, which requires under statute law in Florida that the deed contain particular language. But tenancy by the entireties is a way for only for married people to own real property in Florida. And all the deed has to say is granted to Mr. So-and-so and Miss So-and-so, his wife. And if it says that, that's satisfactory to create a tenancy by the entireties. And what happens with a tenancy by the entireties is that when one of the spouses is deceased, the other spouse is deemed to be the owner of that real property ab initio, as we say in legal terms from Latin, beginning from the initiation or the purchase or acquisition of the property. It doesn't have to be a homestead property. It could be any property owned by a husband and wife or spouses, because it can be other permutations than merely a man and woman marriage. It could be two men and two women. As long as they're legally married, they can have a status of tenancy by the entireties. And what happens is the tenancy by the entireties property, upon the death of one decedent, passes automatically to the other. And the only thing that would be necessary to do is to record a certified copy of the death certificate of the deceased spouse. And that will clear the chain of title to show that if the surviving spouse at some point wants to try to sell that entirety of property, there's not going to be any issue about, well, wait, where's the other spouse and why aren't they signing the deed? Because it will be a matter of record that that deceased spouse is in fact deceased. Now, one thing I haven't talked about yet, but that is the place of the estate administration. I mentioned it briefly. Typically, both France historically and Florida historically and still considered that the last place of domicile of the decedent is the appropriate place to open the principal estate, if you will. In Florida, we have a concept called ancillary jurisdiction for estates. And that would be, for example, let's say you had an estate opened in a foreign country, and then you need to administer some property in Florida. Then you would open what is called an ancillary estate. Sometimes these get complicated because the ancillary estate statute usually is looking for things that are typical of an Anglo-Saxon or a probate kind of estate, and not necessarily an estate administered only by a notary, a notaire. So in Europe, they promulgated a rule probably 7 or 8 years ago, a European-wide rule, in order to create uniform standards for estate administrations. Prior to that, different countries, different jurisdictions followed different rules about determining the law governing the estate. France always followed the law of the last domicile, but for example, Spain followed the law of the nationality of the decedent. And so that created the possibility for confusion and inconsistent results. So the EU regulation, as I say, adopted, I think around 2017, if I'm not mistaken, allowed, made uniform the determination of the place of opening of the estate, but it also provided non-residents who are of European nationality, if they live outside of the EU, the European Union, they are actually permitted by this EU rule to designate the law governing their estate administration. And it's relatively new. It's just about 8 years old. But obviously a rule like that clashed with literally centuries of legal practice. For example, in France, historically, you had a reserved heir right. In other words, if you had a son or a daughter, you could not exclude them from your will. And if you did exclude them from your will, a court would read that will and write in the name of the person who is a descendant of the decedent. That's not true in Florida, and it's mostly not true in jurisdictions following the Anglo-Saxon rules of liberality of testamentary freedom. In other words, here in the United States and Florida, certainly, you can exclude any person from the will. You don't even need to make any excuses. Sometimes people nonetheless will put in a will, well, I've expressly excluded my number 2 son because during his lifetime I gave him many things, or during his lifetime we didn't get along and I didn't want to leave him anything. You can do that. It's not really necessary to do it. But in a French person now can designate a will that would apply the law of Florida, for example, where we don't have the reserve heirs, which is typical of the Roman law jurisdictions. So I want to mention very quickly, because I think we're heading into the time, there's some tax issues that can apply to estates. And the current law in the United States is very generous in terms of offering an abatement to U.S. citizens and lawful permanent residents or green card holders. And the abatement is up to about $12 million, more or less. Now, that statute is due to expire this year, I believe, in 2025. We'll see if the United States Congress can act in a way to either preserve or maintain that. It's a little bit up in the air right now, but it's quite a different situation for non-residents of the United States, particularly if they have estate assets in the United States, because the abatement for non-residents outside the United States is only $60,000. So it's quite a bit of a difference there in terms of the potential tax impact of your estate in the United States. Now, before we finish up, I want to talk a little bit about what we call estate planning in the United States. It's not strictly connected to probate, but it is something that can be used to avoid probate, for example. A lot of people think, well, probate is cumbersome, it's expensive, they don't want to be involved. And there are a couple of different mechanisms that one can employ to avoid as much as possible the probate process. They also can work to reduce estate taxes in addition to avoiding probate entirely. One of those means is what we call the life estate, or the usufruit, as we mentioned. And the life estate would maintain the property in the name of the property holder for their life, as it implies, and then once they passed away, then it goes to the remainderman, or the new propriétaire, as they say in French. The traditional life estate in the United States, and particularly in Florida, was found to be a little bit cumbersome, however, because once the person created the life estate, they were then bound to have the remainder person, or the new propriétaire, join in any change to the property status after the life estate is instituted. And so sometimes we talk about in the United States a so-called ladybird will, or what we call in more technical terms, an enhanced life estate, which actually preserves for the grantor of the life estate the right to actually sell the property, alienate it, which in French would be called the right of abusus, the right to not necessarily to abuse or destroy, but to simply to sell the property. And so the ladybird deed permits the owner of the property to be able to sell during their lifetime without having to get the remainder parties to join on the deed to sell the property. And obviously it will be clear for the chain of title when you are dealing with an enhanced life estate deed that the remainder interests are not required to join in the deed. So the last thing I want to talk about briefly, which could be a whole day's seminar or webinar in itself, and that is trust. And a lot of French people are curious about trust. Trust is something that is derived from traditional Anglo-Saxon law. It's been in existence as a principle for many hundreds of years, maybe close to 1,000. It's not something that exists organically in French law. However, in countries such as France are increasingly becoming sensitized to trust, and in fact, they have passed legislation in recent years that requires beneficiaries of a trust, of a foreign trust in France, must make a report on an annual basis about the trust and its assets and whatever benefits they received. So it's not a simple matter to just say, well, I'm going to make a trust here. You know, I'm a French person, I've got property in the United States, I'm going to make a trust and protect it from probate and give all the benefits to my children, my 3 children, whatever number the children are. it's not a huge issue, not a huge problem, but it will put an additional obligation upon those beneficiaries of the trust in terms of making reports. But what a trust is generally is similar to, but not exactly like creating a personne morale, a legal entity, and putting the property in the legal entity, except the trust is not really a legal entity. The trust is divided in its duties between a trustee who is considered to be the legal owner of the property and the beneficiaries who are considered to be the beneficial owners of the property. But the main point for purposes of our discussion today is that property that is actually put into the trust, because it's not enough to create a trust instrument. You must actually convey or transmit property to the trust. But once in the trust, that property is no longer a part of the estate of the owner or the settler of the trust, the person who created the trust. And so that is a way to avoid probate. Not always the best solution. By the same token, it's not always the solution only for the mega wealthy people. It can be for normal people too, but not for everybody. But it is a means to control not only the administration in probate, but also the tax situation, because the trust assets are no longer part of the estate or really of the property of that person once the conveyance is made to the trust. So I hope I haven't gone overtime. If I have, I hope that you enjoyed it and got a lot of information nonetheless. I thank you all for your attention, and I'm happy to take a try at answering some of the questions that may have come up during the course of the presentation.
Thank you very much, David. So I will share now, just so you know, your contact info. So everyone who would like to be able to contact Mr. Willig, the informations are on the screen now. If they're not right, Mr. Willig, please let me know.
No, they're right. Thank you very much. I appreciate that.
Wonderful.
Or
So
they
we
can
did
go on
have,
framco.org. It's on our website. He's a member of the French Chamber.
Yeah.
that as well. You're right, Betty. Thank you for making the precision.
Let me just quickly add, if I may, about the Florida civil law notary. It's not exactly like the notary in France and can't do everything that a notary in France can do. However, if you're here in Florida or even in other states, because I've had people come from states as far as Ohio to do authentic acts with me as a Florida civil law notary. I've done many of them that were destined to have their effect in France. Frequently working with notaire in France, for example, if you're not able to travel and you need to give a power of attorney to one of the clerks of the notaire, we can handle that as a Florida civil law notary, even if you live in another state of the United States. We're practically one of the only states that has that. And some of you may know that about 5 or 6 years ago, more or less, the French consulates worldwide no longer did notarial acts for French people. And so at the time, the Ministry of Foreign Affairs in France circulated a directive that was quite complicated, explaining, well, you don't have notaries in the United States, so you have to have a lawyer who can speak French, or an interpreter or a translator. It was a very complicated and cumbersome process. Sometimes authentic acts under French law and in civil law in general require the reading of the act, going back to a time in years past when not as many people were literate, and so they understood, but they couldn't read the act. So the notary read the act aloud, and I've actually been witness to those. I have been involved in transactions where people have given me a power to sell a property in Switzerland, for example, and I went to a notary's office, and of course the notary read the entire act. And so if you have an issue like that in Florida, we can help. And if need be, we can read the act in French, not a problem. So I just wanted to mention that for some of you who might be curious about what is a Florida civil law notary, quite different from a notary public.
Thank you, Mr. Willig. So just so you know, to ask the questions, I do have to stop the sharing to be able to see the questions right now. So I will stop sharing the screen and I'll put it back again at the end. But to start with the questions, the first question was from Richard. And Richard asked, so maybe some of the question might have been answered later in the webinar, but I just want to go over them again to give a straightforward answer. What is the procedure in France when a US person with no will dies owning French real estate property? And there's going to be a follow-up question with that, which is, what is the procedure in France when a US person with a Florida will dies owning French real property?
Okay. Well, let me start with the second one first. Under the normal principle of having one will just as one has a single spouse at the same time. You normally should have one will. I did mention during the course of the presentation, sometimes people like to do a will for property in one jurisdiction and a will for property in another jurisdiction. It's not impossible. It's not improper. It can be done if it's done properly. A Florida will, if it is the sole will of a U.S., I'm not sure if it was a U.S. resident or a U.S. citizen resident in France, but if that's the will, that's the will. And if it's a U.S. resident with property in France, again, it won't really matter if there's a will or there's not a will, because it involves real property in France. It will be dealt with or administered in France under French law, likely by a notaire, unless somebody has a dispute over the property. And I've actually been involved in such disputes in France. The typical scenario is children of a first marriage and a surviving spouse of a second marriage. And oftentimes they do conflict about what's going to happen with property. They are considered to be in indivision, which is it's a property concept that doesn't really exist in the Anglo-American jurisdictions, but they both own the property more or less. I guess you could say it's something like tenants in common in Florida in the U.S. Oftentimes it will end up in court to resolve the matter of the dispute over those, as I say, surviving spouse and descendants from a first marriage. And those cases usually fall outside the scope of what a notaire can do in France. But in either case, the French real estate would be administered under French law, whether by a notaire or by a judicial court, who in the case of that kind of indivision case would ultimately name the typically president of the chamber of notaries in the region to appoint or name a notary to do the division of the property to the benefit of those formerly warring parties.
Thank you, Mr. Willig. So I hope, Richard, that helped answer your question. I believe it did. Sebastian next. Sebastian, it's good to see you, by the way. Sebastian had a question for you. It was, hi, David. I have potential clients interested to leave money to charities. Is it better to set up a trust, like a charitable, for example, or just list the charity as beneficiary on the assets?
Well, you can do either one, really. I'm not sure if it will make much difference. One difference, though, would be that if you name the charitable organization in the trust, they might be current beneficiaries of the trust, and that might give rise to some kind of distribution even before the death of the settler of that trust. As I mentioned, the settler of a trust is the person who creates the trust. If it's named in the will, and you can certainly name charitable organizations as recipients in a will, the will has no validity until the testator or the testatrix passes away. And that's why you can make and remake your will any number of times before you pass away. And also, let me just mention, and we talked about the potential for two wills. Another way to resolve that issue is if you have a will and then you either acquire property thereafter, you can make a codicil to the will. And I've had instances, for example, with Canadians, Quebecois, who maybe have property in Florida, so they make their will in French, but they make their codicil to dispose of their U.S. property in English, because the probate court ultimately will deal with that, and that avoids having to translate the document. It seems like it can be cumbersome, but in most cases, it really isn't.
Thank you, Mr.
So I hope I
Willig.
answered the question for Sebastian.
And Sebastian, if you have a follow-up question, you can also drop it in the chat right now. Don't hesitate. And also, just as a reminder, you can also contact Mr. Willig after this webinar. I'll put again his contact info at the end of the webinar, and it's on our website. Karine now has a question. Is Florida getting closer to recognizing TOD on real estate?
Transmission on death, is that what they mean by TOD?
I would believe so. So let's say yes, and Karine, if it's not that in the if it's not that in the chat, please let us know. But I believe so.
So if I can try to address it, I don't know if who was it? Was it
It was
Karine?
Karine.
Okay. Transfer on death. Okay. So we mentioned it. The transfer on death can come in a couple of different ways. It can be a tenancy by the entirety's deed between married people. It can be a deed for joint ownership with right of survivorship, which requires particular language in the deed when it's granted. And the joint ownership will cease once one of the parties dies, and the surviving party will then own all of the real property. Now, as far as TOD, I see Karim mentions to checking and savings accounts. TOD is valid for accounts such as bank accounts, securities accounts, retirement accounts. And there's actually a statute in Florida that says where you have a designation of a beneficiary for those kinds of accounts. I'm not talking about real estate now. I'm talking about what we call personal property or bien meuble. The transfer on death actually takes precedence over a transmission by a will. So if you have a will, but you also have a designated beneficiary, the designated beneficiary will get the property and not anybody who's named in the will.
Thank you again, Mr. Willig. Now we're going to the question from Valerie. If a French resident owns a rental property in Florida, does he need to have a will in Florida to make things easier?
I would say, since you couch it in terms of to make things easier, the answer is yes. Because if not, it's going to be subject to a French administration. The notaire might not know what to do. It will almost certainly end up in an ancillary estate situation in Florida because neither the notaire nor a judicial judge in France will have any jurisdiction or competence over the property in Florida. So when you put it in terms of make things easier or simpler, absolutely yes.
Wonderful. I think that was a very straightforward answer. We're moving on to a question from Anne Bird. Does the $12 million rule of abattement, I believe it was, does it apply for US citizens for the assets they own in France as well?
I would say it would depend on what assets are owned in France, because typically movable property, or what we call in English personal property, is deemed to follow the domicile. So, for example, if you have a bank account in France, but you're domiciled in Florida, normally that bank account corresponds to the estate administration. However, if you own real property, that's going to be different because that will be subject to the law of the situs, or the place where that property is located.
And so I believe it is about property because Anne just made a comment that said 2 apartments in the
So that's
comment.
real property. And wherever those apartments are found, that's the law that will govern the transmission of that property.
Wonderful. Valerie Janberg said that you're a great speaker, by the way. I see that in the comments.
Thank you very much.
We're moving up to another question from Sebastian that says, thank you, David. For people with different retirement accounts and assets, do you recommend simply having a living will or a revocable living trust makes sense as well?
Okay, well, a living will is a little bit of a misnomer. In Florida, a living will has nothing to do with transmitting property. It's really about end of life directives for medical professionals and the like, designation of a person who will communicate with medical professionals when the person afflicted is not able to do so. So a living will has nothing to do with transmission of property. What was the other part, Charles, if I may just ask you to remind me? A living trust?
It was a revocable living trust
Okay.
makes sense as well.
All right, so a trust, if it's revocable or irrevocable, can make a difference. If it's revocable, US law at least considers that because you retained a power over the assets in the will, that those assets are actually deemed to come back and be part of your estate. And if it's irrevocable, then it's whatever belongs to the trust then belongs to the trust. So did I answer the whole question, or did I just get a part of it, Charles?
I
can't really
believe
see
you'd
them.
answered the whole question. And
I did?
Sebastian, again, don't hesitate to drop something else in the chat if not, but I believe you answered
Okay.
the question. Moving on to a question from Paola,
Oh,
which
you know what? They did actually ask if the 12 million is based on include French assets. What I was getting at was, if it's a bank account, it would, and if it's an apartment in Paris, it would not.
that's very straightforward. Moving on. So Paola, LLC in Florida, but residence in Europe. What's happening to the survivor, which is my husband and I are the only members of the LLC?
Well, the LLC is a a legal entity, a personne morale, and it will continue to exist after the death of its owners. And who are its owners? Just like shareholders in a corporation, the owners of an LLC are called members, and they have member interests. And the member interests are like shares, and those shares are movable or personal property. And so it may be a situation where if the decedents, if both decedents, because remember, there might be, if it's a couple, there's going to be two members of the LLC in most cases. And for example, if one of them dies, the half of the member interest will be subject to the estate administration of the decedent. If both of them die, then all of the member interests will be subject to the administration of the decedent's estate assets. And so because they are movable property or personal property, they would likely follow the domicile, where again, if you have people, French people domiciled in France with an American LLC, a Florida LLC, those membership interests, like shares in a corporation, will follow the domicile. And it might ultimately involve perhaps an ancillary proceeding, because it's not really a transfer of real estate, it's a transfer of personal property, the estate, the shares or the member interest. So it may or may not require intervention in an ancillary estate in Florida, but it may be confusing for the notaire, who may not really understand what to do. And certainly, you know, the notaire can, I guess, consult with a legal professional in Florida if they can find one. And nowadays, it's never been easier to find one. So shouldn't really be that complicated.
We have two more questions that appeared while we were chatting, actually. So there's M. Byrne. How do you handle succession when you're a US citizen and your kids are French citizens?
You know, the citizenship is not of such great importance. And the most important aspect is not the citizenship of the parents, but the domicile of the parents at the date of death. And the French citizens, the children, are entitled to the property just because they are entitled to the property, whether by intestate law or if the will names them to be the heirs to that property. But there really shouldn't be any distinction in terms of the rights to the property. The French heirs, if it's a mostly U.S. estate, might be very happy to know that they're not going to be liable for the passive portion of the estate personally, and that whatever creditor claims are made will, in almost every case, be resolved before the closing of the U.S. estate. And so it may bring greater peace of mind to those French citizens, but it doesn't really affect their entitlement or the ability, legal ability, to take property from the estate of their parents. Now, it might add to their, for example, if there's a tax on not an estate tax, but the tax on the fortune of the person. Obviously, it's going to increase that French person's fortune and may subject them to additional taxation in France, which has a number of taxes that we don't really have here in the United States that some people find a little bit onerous.
That was the next question, actually, for Mr. Ben. I see he just dropped it in the chat. What about taxes? So you got ahead of that, I think.
Yeah.
There's one last question just before. I want to thank as well Randy and Anne and Sebastian, who are all thanking you for the presentation and the Q&A session, Mr. Willig. Last question that I see from Valerie Janberg. Should French buyers purchase a second home as an LLC or under their names in the USA?
Well, most of the reasons for purchasing a home as an LLC have very little, if anything, to do with probate and successions. Normally, people, in fact, most real estate brokers in properties in Florida urge their French buyers to have an LLC. Mostly it's to protect from liability. And it may be that French people are especially sensitive. They may have heard stories about the litigious society in the United States, where it's very easy to sue, and the courts are very accommodating to people who sue, even if they sue without a lawyer on their own, as they call it, pro se. And so the LLC will provide some level of protection, because if, for example, something happens in the apartment, it's going to be the LLC who's going to be the first line of defense before you would have a situation where you could look through that corporate entity or limited liability company entity and apply the liability directly to the members. Very, very rarely happens, but it can happen. There are conditions under law with which a party may look through the corporate entity and go after the parties themselves. But typically, if you have a property in the United States or in Florida, in an LLC, if you have a mortgage on the property, you're going to have to insure the property. And that's going to be your very first line of defense against a lawsuit. They're going to go against the LLC, but the LLC is going to have an insurance policy. Now, as far as for estate purposes, I mentioned that the LLC membership interest will be considered to be personal or movable property. And so to fully analyze that, you need probably a little more facts about who the parents are or who's buying the LLC or what they intend to do with it at the end. And certainly they can make a will that says, I give all of my LLC member interest to my son number one, my son number two. But the other thing is, in the context of avoiding probate, you can actually create a usufruct or a life estate of the membership interest in the LLC as well, which will have the effect that when the member who owns the life estate in the membership interest in that LLC, when that person passes on, the LLC member interest will pass automatically to that remainder interest party. So that's falling in the category of avoiding probate. And it might be a simpler way to do it rather than just having the heirs to the movable property, because as I mentioned, movable property follows the domicile, whereas real property follows the situs, and the membership interests are movable property.
Thank you, Mr. Willig. So just so you know, I saw some people just joined it as well. You guys are a little bit late. However, there will be a replay again on our YouTube channel, and I will email shortly, I'm not sure when, but shortly, the replay, the webinar replay to all of the people who signed up and attended today's webinar. I don't think there is any questions, so I would like to thank you, Mr. Willig. And if there's anything else you'd like to say, I'm going to share as well your contact info again.
Thank you. And I would
Yes.
like to say thank you not only to Framco, President Betty Kappa, and Charles Tuvino, Director, but also to all of those attending today. I appreciate your attendance and your attention, and I remain at your disposal if later on you have some questions. As you can see, the contact information. I'm actually very easy to get a hold of, and so I would encourage you, if you do have any later questions, or if you have a matter that involves some of the things we talked about, I'm happy to help you out.
Thank you, David. Thank you, everybody. And that was wonderful. A lot of information. I really, really appreciate you. Thank you so much, David, and everybody
you.
who attended. Have a
Well,
good
on
day.
those last things, we'd like, once again, thank you everyone for attending. Thank you, Mr. Willig, for this wonderful presentation, and hopefully
pleasure.
we'll see you all at the next webinar.
Thank you very much, and a good day or a good evening to all.
Thank you.